Good afternoon, everyone, and welcome to today's webinar, Housing Matters, Legal and Policy Approaches to Preventing Housing Instability, brought to you by the Network for Public Health Law and the American Society of Law, Medicine, and Ethics. I'm Charles Strong, the Senior Digital Marketing Coordinator at the Network's National Office, and I'll be your host for today's webinar. A quick note that both the presentation slides and video playback for this webinar will be available on the Network's website shortly after the conclusion of today's event. We strongly encourage attendee participation, so feel free to submit questions at any time during this webinar by using the Q&A tab on the right-hand side of your screen. All you need to do is click on that tab, select all panelists from the drop-down menu, and send us your question. We'll be addressing questions towards the end of today's events during the Q&A portion, and if we are unable to get to your questions, then we will do our best to follow up with you after the webinar. Your moderator for today's event is Carrie McGowan Lowry. Carrie is the Deputy Director and Director of Grants and Research at the Network for Public Health Law's Eastern Region Office, where she provides legal technical assistance on a variety of public health topics. Her current work focuses on empirical legal research and coding, injury prevention, and child and adolescent health policy. Carrie will be leading us through the rest of today's webinar. So Carrie, over to you.
Thanks, Charles. Hello, everyone, and thank you so much on behalf of the Network for Public Health Law's Eastern Region Office for joining us today for this really important discussion. Again, our team is with the Eastern Region Office, which is based at the University of Maryland Carey School of Law in Baltimore, Maryland. You registered for this webinar, so I'm sure it goes without saying that housing stability is a major determinant of health, a fact that has become clearly in focus during the pandemic and particularly. COVID really has shined a spotlight on existing housing inequalities, inequities, and the laws and policies that sometimes serve to perpetuate them. Today, we have a panel of three excellent speakers: Delaney Anderson, Kyle Correga, and Molly Soloway. Delaney, Kyle, and Molly are truly exemplary third-year law students at the University of Maryland Carey School of Law, where they are student attorneys with the Public Health Law Clinic. They've been researching and studying housing law and policy approaches to promote housing stability, reduce evictions, and prevent homelessness. They've also prepared and delivered testimony on these important issues before the Maryland General Assembly and the Baltimore City Council. I'd also like to highlight that over the course of the next several weeks, the network will be posting a series of fact sheets developed by our speakers today that mirrors the topics that they will be addressing. And those are housing instability as a social determinant of health, deterring serial eviction filings, eviction diversion and prevention programs, right to counsel in landlord-tenant matters, and limiting access to eviction records, as well as an accompanying law and policy pathways document. So please be watching your network report for an announcement on when those will be posted. This is an aside, but if you are not already signed up to receive the biweekly network report, I would really encourage you to do that. Visit the network's website and click on Connect with Us, the button in the top right-hand portion of the page. Again, please feel free throughout the webinar to type your questions into the Q&A box. I will be fielding those during our Q&A session at the end of the presentation today. And without further ado, I would like to turn things over to our first speaker, Delaney Anderson. Delaney?
Great, thank you. Hi, everyone. As Carrie said, I'm Delaney. Molly, Kyle, and I are all very excited to speak with you today about a number of these laws and policies that Carrie spoke about to address and respond to housing instability in your communities. So we want to start this webinar by first identifying and detailing the problem at issue here, and that is the public health impacts of housing instability. As Carrie said at the beginning, housing is a social determinant of health. This means that it's a key condition in the places where people live, learn, work, and play that affects both their health and quality of life risks and outcomes. So what that tells us is that housing and health are coextensive. They influence one another. Medical conditions may lead to homelessness, and homelessness may itself exacerbate existing chronic health conditions and also create new health conditions. People who experience homelessness in particular report poor health overall, including higher rates of diabetes, high blood pressure, heart attack, hepatitis C, HIV, substance use disorders, intimate partner violence, and mortality. Homelessness itself also makes it more difficult for people to access treatment, manage their medications, access consistent and or healthy food sources, and protect themselves from weather extremes and communicable diseases. Then people who experience housing instability more generally, so not specific to homelessness, still experience a range of those negative health impacts. These people get caught in a spiral of instability that exacerbates their associated health impacts. So people who are threatened with evictions are more likely to have overall poor health outcomes, such as high blood pressure and psychological distress. Families who are evicted also report poor mental health and financial impacts. And children too show these signs in struggling to build friendships and excel in school, while also being more likely to develop behavioral problems. Now, as many of you I'm sure would expect, these health risks are even greater post-COVID. I do want to be clear in stating that this pandemic did not cause the eviction and homelessness crisis in this country, but it has exacerbated it. This image details that pre-pandemic homelessness was still on the rise with a disproportionate impact on minorities. However, what COVID has done is add this particularly dangerous combination as it pertains to health, a lack of opportunity for physical distancing and space with the loss of income and financial hardship. One study found that people who are homeless with COVID are at least twice as likely to be hospitalized, to require ICU treatment, and to die. And research shows that after moratoria to stop eviction throughout the country lapse, there will be a spike in COVID contraction and mortality. And so finally, I also want to emphasize that housing instability is not just a public health crisis, it is in itself a health equity crisis. So we see that it disproportionately impacts communities of color in particular. Black renters are disproportionately targeted with eviction filings, and this has only been amplified since COVID. Black people make up 13% of our general population, but 40% of our homeless population in the United States. And homelessness, again, affects many other communities at disproportionate numbers, including single mothers, domestic violence victims, LGBTQ youth and young adults, people who were incarcerated, and veterans. These numbers show that housing instability is as much a crisis in equity as it is in public health. So these are the problems that the laws and policies we're talking about here are designed to address. But before we jump into those, I wanted to give a brief and simplified overview of the eviction process. Please keep in mind that this will definitely depend on where it is that you live, and all these steps may not be present in your state or jurisdiction. But just want to give a brief overview. So the first step is that the landlord gives the tenant notice about the landlord's intent to file for eviction. Again, may not exist in all jurisdictions. Here in Maryland, this does not exist for failure to pay rent cases, actually. Second step is that the landlord files the complaint in court. This will result in the tenant being served with notice of the complaint and with the hearing date. Third step then is that an eviction hearing takes place to determine whether the court will order eviction. If the court does order eviction, it will give the tenant a number of days prior to vacate the property. Fourth step then is that the landlord schedules tenant's removal, and if the tenant does not move out after the order, the landlord can have the sheriff remove the tenant. And then finally, the last step that we talk about here more is that the tenant copes with the eviction filing being on their record moving forward. So with these steps in mind, these different laws and policies will work to ensure fair and equitable outcomes at all steps in this process that I've just detailed to you, to avoid eviction and by extension, those negative health impacts that we talked about. And with that, I will pass it to Molly to discuss our first policy.
Thanks, Delaney, and good afternoon, everyone. I'm going to talk about the first of our 5 policy pathways, which is targeted at the very beginning of the eviction process that Delaney just described. So in fact, these policies specifically aim to decrease the number of eviction filings by addressing the practice of serial eviction filing. Before we get into what the practice is and what it looks like, I just want to provide a little background. First, when we're talking about an eviction filing, we're talking about what is usually the second step of the process when a landlord files a complaint in court. And when we talk about an eviction or an executed eviction, we mean the actual displacement and removal of tenants from their homes. So between 2000 and 2016, landlords filed more than 61 million eviction complaints in the US. That's roughly 1 eviction filing for every 17 renter households in the country. Fortunately, not all eviction filings result in an executed eviction. So during that same period, 1 in 40 renter households were actually evicted. Statistics from here in Baltimore City present a particularly stark example. There are roughly 140,000 annual eviction filings for just 125,000 rental units. That's an eviction filing rate of more than 100%. But of those 140,000 filings, only 6,500 result in an actual eviction or displacement of the household. That's an eviction rate of 4%. There are several reasons that we see such a disparity between the number of eviction filings and the number of executed evictions. In some cases, tenants are able to pay the back rent they owe or otherwise cure the violation of their lease. In others, tenants prevail in court, or tenants and landlords might be able to reach an agreement to avoid displacement. But recent research has shown that this disparity is also due in large part to the practice of serial eviction filing. While some landlords only turn to eviction as a last resort, others, particularly large corporate property owners and managers, file for eviction against a tenant not only as a means of removing the tenant from the property, but as a means to collect rent and additional fees. So this is what we mean when we refer to the practice of serial eviction filing. And just to be clear, when we're talking about landlords in this context, we're mostly talking about those larger property owners and managers, not smaller landlords who own or manage just a few properties. So in 2014, nearly 1/3 of households facing eviction nationally were filed against multiple times at the same address. And in some jurisdictions, that number is even higher. So why is this a problem? As Delaney discussed earlier, eviction results in a range of long-lasting physical, psychological, and economic challenges for evicted individuals, for families, and for entire communities. But even if tenants are not evicted, these repeated filings still have a range of negative impacts. These include the addition of unnecessary administrative costs, clogged rent court dockets, landlords gaining coercive power over threatened tenants. We know, landlords know, that tenants living under the threat of eviction are far less likely to exercise their legal rights to safe and habitable housing. Tenants are also, in these cases, living with the psychological and emotional impact of what has been referred to as an extended and repeated state of insecurity. These filings themselves also create a durable public record that limits future housing options far into the future. And Kyle will be speaking more to that later. And lastly, these filings also translate into additional fines and fees that are most often passed on to tenants. Research done by the Eviction Lab at Princeton University found that each eviction filing results in an average of $180 in fines and fees, raising average monthly housing costs by 20%. So what we see is that serial filing rates are higher in jurisdictions where filing for eviction is cheap and easy, and they're lower in jurisdictions where barriers are high, suggesting that state and local governments may be able to deter serial eviction filing by making the process more costly to landlords. Here we're going to look at 4 specific policy approaches that might be used to deter these unnecessary eviction filings. They include increasing pre-filing notice requirements, increasing eviction filing fees, preventing filing fees from being passed on to tenants, and requiring landlords to have clean hands. So as Delaney mentioned, most but not all states require landlords to provide tenants with some kind of advance notice before filing an eviction in court. This gives tenants a chance to pay the back rent that they might owe or to otherwise cure the lease violation that is the basis for eviction before a court record is created. And research shows that greater notice requirements are correlated with lower serial eviction filing rates. But even among states that require notice, there's substantial variation in elements like the required length of the notice period, what information, if any, must be included in the notice, and how the notice is delivered. So we've included here some examples of state-level notice requirements. You can see that the standard notice period is generally fairly short, but varies from as little as 3 days to as many as 30 days, depending on the reason for eviction and the state. It's also notable that in some states, landlords may include provisions in the lease that remove the need for notice entirely. You can also see that some states like Tennessee have no requirements for what goes into the notice or how it is delivered, other than that it's in writing, while others like Texas only have requirements for how the notice is delivered. Delaney also mentioned Maryland is one state where there is currently no requirement at all for notice in failure to pay rent cases. There are several proposed bills right now before the General Assembly that would require that notice and would specify what must be included. I also just wanted to note that in cases where local governments find state requirements insufficient, there is usually a possibility of adding requirements at the local level. So San Jose is a good example of this. Under California state law, landlords only need to provide a tenant who fails to pay rent or violates the rental agreement with 3 days notice in writing. But the city of San Jose additionally requires landlords to include with their eviction notice a list of resources for tenants, and also to submit a copy of the notice to a government agency, allowing for the possibility of earlier outreach and intervention. So moving on to our second policy, this involves increasing eviction filing fees. Since policies that increase the cost to landlords are negatively associated with the number of eviction filings, increasing these filing fees is a common sense approach. The average cost nationally to file for eviction is estimated to be between $112 to $120. But as you can see, these fees range substantially from jurisdiction to jurisdiction. Maryland and DC have the lowest filing fees in the country at just $15, and Minnesota has the highest at roughly $300. So one possibility then, especially for states with lower filing fees, is simply to increase them. There are ongoing efforts in both Maryland and DC to raise these fees closer to the national average. In Maryland, these efforts are currently before the General Assembly and are championed by the Attorney General. While in DC, the City Council has asked the Superior Court to review its fees, which it's now doing. And the benefits to increasing filing fees are multidimensional. So higher fees should result in fewer filings, which lessens burden on tenants and reduces the administrative costs to courts. Higher fees also create more revenue, which can be used to support civil legal aid or other legal services. Our third approach is to prevent these fees from being passed on to tenants. So many landlords include in their lease a clause that requires tenants to bear the burden of court fees, meaning that even higher filing fees might just simply be passed along to tenants who are already financially burdened. In order to ensure that these higher fees act as a true deterrent to serial filing and don't just increase burden on tenants, jurisdictions may wish to expressly prohibit landlords from writing these clauses into their leases or from otherwise passing these fees along to tenants. This seems to be a pretty new approach, but there are 3 bills here in Maryland currently before our General Assembly that include language that would do just that. So all of the previous approaches have served to prevent landlords from filing for eviction in bad faith. And another approach to doing that is to prohibit landlords with housing violations from filing for eviction. These policies are sometimes referred to as clean hands requirements. And not only do they have the potential to limit eviction filings, they also serve to protect tenants who exercise their legal rights to safe and habitable housing by preventing landlords from filing for eviction in retaliation to a complaint. As an example, there's a bill currently before the New York State Senate that would prohibit landlords in New York City from bringing an eviction case for failure to pay rent if the building is in violation of a building code. And in Philadelphia, the mayor's task force on eviction prevention and response has made several recommendations for policy changes to the same end. The recommendations include creation of a rule that would enable the courts to reject any eviction filings if the landlord does not, at the time of filing, have a rental license, a certificate of rental suitability, a lead-safe certificate, and proof of having provided the tenant handbook to tenants. So just to sum up this section, filing for eviction is simply too cheap and too easy in many jurisdictions, which encourages landlords to use the process as a form of rent collection. These four policy approaches in different ways seek to make the process more costly and difficult in an effort to deter landlords from turning to the legal process as a first rather than a last resort. And with that, I'm going to pass it over to Kyle to discuss our next policy pathway.
Thank you very much, Molly. Our second policy focus takes us one step further into the eviction process and looks at tenants in crisis. For the past 10 years, cities, counties, and states have begun to adopt programs that can save a tenant before an eviction hearing or before the case is even filed. And these programs are generally called eviction diversion or eviction prevention. The basic idea behind these programs is that early intervention helps everyone, landlords, tenants, and communities as a whole. For tenants, the programs are a lifeline. They can save a tenant from all of the disastrous health and economic outcomes Delaney discussed earlier. Although numbers vary by jurisdiction, studies place the success rate of these programs at anywhere between 2/3 and above 90%. For landlords, evictions can be surprisingly expensive. While eviction filings are often cheap and effortless, the actual eviction process comes with surprising costs, ranging from months of lost rent to wasted time, unit repairs, legal fees, and administrative costs that some studies have found add up to over $10,000. If a tenant is months and months behind and has no prospect of repaying, those costs can be worth it. But that's not the average tenant. Studies have shown that as many as half of all evictions could be solved with payments of as little as $1,000 to $2,000. So in most cases, and particularly for small mom and pop landlords, eviction is disproportionately expensive. And finally, for communities, these programs have led to sharp decreases in case filings and actual evictions, addressing the problem of administrative costs and clogged court dockets that Molly referenced earlier. The state of Michigan has been a leader in this field. Its first eviction diversion program was adopted in 2010 by the city of Kalamazoo. The Kalamazoo program offers a bundle of support services such as emergency housing funds and pretrial mediation to renters with less than 3 months of back rent and an income below the area's 40% median. Now, the program was implemented in 2010, and from 2011 to 2015, Kalamazoo saw a 50% decrease in evictions and a 9% decline in overall homelessness. So this program has been wildly successful, and it's become a model followed by other jurisdictions nationwide. So how do these programs work? Well, every jurisdiction structures its program differently. They all have unique needs and address it with unique solutions. But the programs tend to fit into at least one of four paradigms. First, notice and tenant education programs give tenants the chance to take action before a case is filed. Second, emergency rental assistance can help tenants who are barely behind stay in their homes. Third, eviction mediation enables landlords and tenants to work out a mutually beneficial agreement. And fourth, collaborative housing courts focus on restorative and corrective justice to help tenants get back on their feet. Turning to our first option, notice periods don't just deter eviction filings, they also give tenants the best opportunity to fix the problem themselves. But there are some problems with notice. As Molly said earlier, while almost every state requires notice, grace periods can be as short as 3 days for late rent, and landlords can sometimes waive the requirement entirely. Also, many tenants aren't aware of their options. They don't have the resources and the knowledge necessary to take advantage of this time. The solution is to provide tenant education services. This can come in the form of formal trainings on basic skills, tenants' rights and responsibilities. Some complexes or programs might offer on-site social services and legal advice, and some jurisdictions publish tenant handbooks or information pamphlets. The best practice seems to be providing point-of-crisis access to these programs. Cities such as Cincinnati and Richmond, Virginia, have designed their eviction summons to include contact information for community organizations or required landlords to include pamphlets with the eviction notice. These approaches allow tenants to engage the services right away when they still have time to recover. The second policy focus is the most straightforward, and that's funding tenants to make up for lost rent. Part of the tragedy of eviction is that the average tenant is just barely behind. The Eviction Lab at Princeton University studied all eviction judgments in 22 states from 2014 to 2016. This research revealed that the average rent owed in an eviction case was only $1,253. And in Richmond, Virginia, with the second highest filing rate in the country, it was only $686. So this is such a small amount to save families from a lifetime of health and economic outcomes. The challenge, of course, is that money doesn't grow on trees. This year, Congress committed $25 billion to states to help with rental assistance, but that is a one-time commitment in an emergency situation. These programs require year-to-year persistent funding and political support. Houston, Texas is a case on point. Late last year, Houston passed a $15 million COVID rent relief fund, and that fund ran out in only 90 minutes after it was available due to high rates of demand. So what is the solution? How do we make these programs last? Well, funds should be calibrated to serve the greatest need and to go to tenants they can actually save. Most jurisdictions with emergency funds only accept applicants below a certain income threshold, such as 40 to 50% of the median. Again, greatest need. Others try to ensure that funds are only distributed to tenants they can actually save by limiting the amount of back rent they subsidize or requiring a partial upfront payment. Of course, we want to help as many tenants as possible, so political support is critical, and it's important to advocate for a high rate of upfront funding. There are a lot of success stories that can be used here. The Boston Housing Authority reported that Boston's Home Start diversion program led to an 84% savings between the cost of salvaging a tenancy and the cost of eviction. Our third option builds off of popular ADR services with pretrial mediation. This idea is to facilitate mutually beneficial agreements, such as settlements and payment plans that meet the needs of both parties. Now, mediation is a collaborative solution, so a mediation program needs to create conditions that foster agreement by incentivizing landlords and tenants to come to the table and giving the court the flexibility to delay the case while parties are negotiating. The upside is that these programs tend to be very popular and very low cost. In Baltimore, a 2016 pilot saw an 85% participation rate from both landlords and tenant, and an 81% settlement rate. And in Kalamazoo, the long-running diversion program I mentioned earlier has cost only $1,100 per family. Now, the drawbacks come in terms of capacity and power dynamics. The lack of formal proceedings in a negotiation can exacerbate inequalities. Landlords hold all of the cards in this relationship, and some commentators have observed that the process has a high potential for abuse if it isn't carefully moderated. So it's important to make sure that negotiations are overseen by trained, experienced mediators, and this requires substantial support and staffing. Now, our fourth and final option is to adopt a collaborative housing court model. This model changes the rent court process to encourage collaborative solutions before eviction and empower the court to help tenants directly. The model builds on ideas of collaborative and restorative justice that have started to become more common in criminal law and drug courts. And it requires three key adjustments to the rent court process. First, judges should be educated in housing law and the public health impacts of eviction. This is often accomplished through judicial training programs and by assigning a set of judges to manage the housing court docket. Second, judges should be given the discretion to extend, refer, or expunge an eviction case while they're working on a solution with the tenant. And third, judges should be authorized to enter the parties into a payment plan, to engage in case management, and to supervise the tenant and keep track of their progress. So just to recap this section, again, there are four general paradigms for eviction diversion: notice and education, direct rental assistance, eviction mediation, and collaborative courts. There's no one right answer. Most jurisdictions have blended these four, and it will be up to each jurisdiction to decide which options meet the moment and meet their need. But the key is to intervene early, before the case is filed, before the worst consequences of eviction can manifest, and while the tenant still has a chance to get back on their feet. And now I'll turn things back over to Molly for our next policy option.
Thanks, Kyle. So I'm going to talk here about legal representation in eviction proceedings, and specifically about establishing a right of access to this representation. So we have this quote here from Matthew Desmond's book, Evicted, which you may have heard about, because it gets at several key points about the right to counsel movement. All right, so while the Sixth Amendment to the Constitution grants criminal defendants the right to counsel, parties in civil matters like landlord-tenant cases do not have the same guarantee of legal representation. But legal representation in these cases can help to ensure the same basic tenets of justice, due process of law, and procedural fairness. So in eviction proceedings in particular, legal representation is largely one-sided. While nationally only 10% of tenants are represented in eviction cases, 90% of landlords are. And as we'll discuss more, tenants with legal representation are far more likely to obtain positive outcomes. Rent courts move quickly in order to handle a large number of cases, and tenants often have legal defenses, legitimate legal defenses, that they don't know about or are unable to exercise on their own. And even when they don't, lawyers can help to mitigate the negative impacts of an eviction. So currently there are civil legal aid organizations and pro bono attorneys who provide legal support to tenants, but they're constrained by resources and funding, unlike landlord representatives. And because of this, often this legal support takes the form of brief advice or training tenants to know their rights, some of the measures Kyle just discussed, rather than full-fledged representation throughout the process. Because there's also no uniform requirement, the legal assistance available to tenants in one court may differ substantially from that available to tenants in another, even within a particular city, let alone a state. So the movement for right to counsel in eviction cases is part of a larger movement to establish a right to legal representation in a range of civil cases. And there are a patchwork of state laws that provide for this right in specific proceedings, including mental health, domestic violence, child custody, and more. And I think it's fair to say that most advocates in this space would like to see this right implemented more broadly, but have focused on the particular importance of representation in eviction cases for several reasons. First, the exceptionally high cost of eviction to individual households and communities that we've been discussing. Second, the inherent power imbalance between landlords and tenants. And third, growing evidence that legal representation can really make a difference in these cases. So while there have been a number of recent attempts to enact federal legislation on this front, what we have seen to date is that the right has only been implemented at the local level. New York City was the first city to implement this right in 2017. And as you can see here, there are now 7 major cities that have done so. And there are 3 more, Santa Monica, Los Angeles, and Seattle, that have substantially begun the process. Most of these cities implemented the right through local legislation, but 2, San Francisco and Boulder, did so through ballot measures. One of the other biggest differences that we see in these measures is in which tenants the right would apply to. So in New York and Philadelphia, for example, families whose household income is at or below 200% of the federal poverty guideline qualify for full legal representation. And just for context, the federal poverty guideline for a family of 4 is just $26,500. In Cleveland, the income threshold is lower, so that only families whose household income is at or below 100% of that guideline qualify. While in Baltimore and Boulder, there's no stated income limit. A number of states have also started looking at enacting statewide measures, and at least 7 are currently considering legislation that would establish the right to counsel in eviction proceedings. As on the local level, there's some variation in which tenants would qualify for free legal representation, and also in how the right would be accessed and implemented. But because New York City was the first jurisdiction to enact the right, and because so many other local and state laws are modeled after New York's legislation, we just wanted to highlight a few key components of New York's law. So first, while only income eligible tenants, those whose income is at or below 200% of the federal poverty guideline, only those tenants receive access to full legal representation. All tenants are eligible for brief legal advice. Second, that tenants are generally entitled to that right no later than their first scheduled appearance in court. Third, that the right extends to administrative proceedings before the City Housing Authority for termination of tenancy or housing subsidies. This is important because we know these actions too also impact tenants' housing stability. Fourth, that the program is being phased in over 5 years. In New York City, that's being done by zip code. And fifth, that the program is reviewed annually, including through public hearing. Interestingly, even though New York has seen a lot of success with this program, last year, advocates began pushing for an extension of the right. So in February of 2020, the City Council began considering 2 additional measures that would first expand protection to all tenants making under 400% of the federal poverty guideline. That's an effort that has been called Right to Counsel 2.0. And second, that would provide funding for tenant organizing groups to better educate tenants on their rights under the new law. Because advocates have realized that most low-income tenants still don't know that they're entitled to a lawyer during eviction cases. For the sake of time, I'm not going to go through all of these specific results, but I want to highlight the trend that we see in jurisdictions where the right to counsel has been enacted. First, that eviction rates have dropped significantly in these areas. Second, tenants who are represented by legal counsel are far more likely to avoid an eviction judgment than those who are not. And even in cases where eviction does proceed, lawyers can help to mitigate the worst impacts of eviction. So they can do this by negotiating to have the tenant's move-out date adjusted, have back rent reduced or waived, have the tenant's housing subsidy retained, have the case sealed from public view, or have the tenant's credit otherwise protected. So before wrapping up this section, I just want to spend a minute talking about the biggest source of opposition to this kind of legislation, which is cost. So the costs of implementation are expected to be high. In cities that have studied the potential costs, estimates are between 1 and 200 million annually, depending on the number of tenants the city expects to serve and the eviction defense services that are already in place. But the measure actually stands to save the state or the city significant costs in the long run by reducing the cost of disruptive displacement, like emergency shelter, temporary housing, healthcare, transportation to enable children to stay in the same school, foster care, and those are just some of the more easily quantifiable costs. So the return on investment is estimated to be at least 6 to 1. For example, according to one study in Baltimore, an investment of $5.7 million in right to counsel is expected to save the state and the city $18.1 million in Medicaid and foster care spending alone. In Philadelphia, the estimate is that for each dollar the city spends on providing representation, it receives a benefit of at least $12.74. So like with other public health measures, these cost savings are not as immediate as the cost of implementation, but they are there. There also may be an opportunity to save on costs by using pro bono hour requirements or law students to help staff these initiatives. And with that, I'm going to pass it back to Delaney to discuss our final policy pathway. Oh, I'm sorry. I think actually I'm passing it to Kyle. My mistake.
Thank you, Molly. So our fourth policy reform focuses on the effects of eviction records. Whenever a landlord files an eviction complaint, that filing generates a public record, and those records are associated with the tenant even before the case reaches judgment. So much like a criminal record, an eviction is made available to the public through the court system and accessible through online databases. There is a real problem with this system. Eviction cases remain in the public record even if the landlord doesn't win. If the case is dismissed, if a tenant is named a necessary party, or even if the tenant wins at trial, they still end up with an eviction record. Now, this is exacerbated by the serial filing problem Molly discussed earlier. In jurisdictions with high filing rates, where landlords treat filing as an arm of the collection process, only a small percentage of cases actually move forward. And as Molly noted earlier, in cities like Philadelphia and here in Baltimore, as many as 95% of filings never go to trial. But those filings still leave tenants with a black mark on their record. The result is what has been called dirty data. Eviction filings that just don't tell the whole story and don't reflect what actually happened. And there's been some remarkable anecdotes about the consequences. In some high-profile studies, tenants have been found with evictions on their record where they were making all of their payments, but the rent was stolen by the landlord's collector, and the case was ultimately dismissed, where the landlord's building was foreclosed and their lease was terminated, or where the tenant was never served with legally required notice. Many of these mistakes simply go uncorrected, even when jurisdictions authorize discretionary action, because the tenant is unaware until they move and seek new housing. So why does this matter? Why do we care about eviction records in particular? Well, one of the most pernicious facts about eviction is that the consequences stick around. Eviction creates this black mark on a tenant's record that can quickly accelerate. The consequences and burdens that result accumulate and plunge the tenant into what has been called a spiral of financial instability that aggravates all of the health outcomes we've discussed throughout the presentation. So eviction records themselves remain visible for the better part of a decade, usually 7 years. They are visible to the public and easily accessible online. These records create debt and harm credit. An eviction judgment is entered as a civil judgment, and the resulting debt strikes down a tenant's credit score. Eviction is also accompanied by ancillary collection efforts that can have further credit impacts. The result is that a tenant struggles to find financial options. Renters who were evicted will be ineligible for favorable loans, and employers may decline to hire candidates with active debts in collection. And to make matters worse, the eviction record itself will harm a tenant's search for future housing. Many public housing options require a tenant to have a clean eviction record, and some landlords use automated screening services that comb the eviction databases. These landlords will see the red flag in the screening report, and this typically results in an automatic denial of the tenant's application, even if they have a perfectly reasonable explanation. This is why Matthew Desmond, in the book Molly referenced earlier, called eviction a cause and not just a condition of poverty. Tenants who are evicted once or have a filing against them and won their case find themselves with poor housing options, poor financial options, and a decade or even a lifetime of diminished opportunity. So what's the solution? What do we do? Where do we go from here? Well, the obvious and most compelling answer is to limit a landlord's ability to use a tenant's prior eviction history against them. Landlords have other superior tools available to evaluate a tenant's current financial status. They can use employment checks, income verification, criminal background checks, interviews, and attestations under oath. Any of these tools will provide a more complete picture of a tenant's ability to pay the rent now than a judgment that can be as many as 7 years old. So eviction record sealing can take one of two forms. The most powerful is expungement, which permanently deletes the record as if it never existed. But more commonly, we see jurisdictions seal these records and close them off to the public so that they can be opened in extreme circumstances. But sealing laws, however they're implemented, need to consider what happens given the outcome of the case. How should the record be treated if the case settles or is referred to one of the diversion programs I discussed earlier? What happens if the case is dismissed or the tenant defends, such as by raising habitability claims about the conditions on the premises? And what happens if the landlord wins? What do we do when the tenant is actually evicted or exercises their right to redeem the property before eviction but after judgment? Here, at least, the record is accurate, but tenants who are evicted are in the most vulnerable situation and have a compelling need for financial stability. There has been a trend towards record sealing laws in states and municipalities nationwide. 4 states now use some form of automatic or mandatory sealing. Several more have discretionary options, and a number of cities have begun to experiment with similar legislation at the local level. Support for these policies is accelerating during the pandemic. Right now, as many as 30 million Americans could be at risk of eviction when the moratoriums lift. Ongoing federal and state relief efforts will help to some degree, but there's still a substantial risk that millions of families will end up with an eviction record at a time when we're trying to reopen the economy. As a result, a number of states, such as Maryland, now have pending eviction sealing legislation during their current legislative session. So each of the 4 states with some form of automatic sealing takes a different approach, and each has some drawbacks. Minnesota allows discretionary expungement for meritless filings where the interests of justice favor the tenant, and only provides mandatory expungement in extreme circumstances, such as where the tenant is a holdover due to a foreclosure of the rented premises. But Minnesota's mandatory protection is very narrow, and this discretionary provision has been criticized as time-consuming and costly. Oregon is slightly more protective. Oregon authorizes mandatory expungement if the case has been dismissed, the parties have settled, and the tenant is paid up, or 5 years have passed and the tenant's debt is paid. But this still requires the tenant to move to expunge and places the burden on tenants to litigate. It also disincentivizes settlement, as tenants won't be protected until they've fully complied with the settlement terms. Nevada and California offer a stronger approach. These states address the problem of false positives by automatically sealing records if the tenant wins or the case is dismissed. And that's a good thing. That's a good start. But they have different approaches if the landlord wins. In Nevada, the state takes a page out of Minnesota's book and allows discretionary sealing if the landlord prevailed. So there isn't much in the way of guaranteed support for tenants who have been evicted. In California, on the other hand, the state will automatically seal records unless the landlord wins in the first 60 days or the court grants a motion to unseal. This is probably the most protective approach of the 4, but many tenants are evicted in summary proceedings. So there's a critical need to provide diversion programs, access to counsel, and all of the other policy solutions we've discussed today to level the playing field and give tenants an opportunity to defend. Now, in some states and cities, particularly where there's high opposition to sealing eviction records, they've experimented with alternative solutions that offer at least some protection. In Wisconsin, there's a requirement that records are not accessible on the web after 2 years. In Minnesota, the state requires accuracy in tenant screening reports and gives the tenant the right to demand correction of any inaccurate data. And New York City's experimented with some unique solutions, such as making housing participants a protected class and requiring automated screening reports to include the case disposition. All of these approaches are a good first step, but they come with substantial enforcement difficulties, and they often place the burden on the tenant to assert their rights. For low-income tenants who don't have the knowledge of the eviction process necessary to realize that their future opportunities are in jeopardy, these laws are not sufficiently protective. So the best policy solution is actually the simplest: sealing or expunging records at the point of filing. Blanket sealing avoids the complexities, inequities, and enforcement challenges presented in the alternatives and does not require tenants to litigate and assert their rights. It also minimizes the risk of false positives and dirty data. Now, again, landlords may criticize this program as prejudicing their ability to screen tenants, but that's not really true. This approach saves tenants without harming landlords. Once more, landlords have plenty of other options to assess an applicant's financial stability, and these options are more accurate than records that can be as many as 7 to 10 years old. For tenants in crisis, they have no other option. The best thing we can do is protect them against the effects of a single eviction case at the worst moment in their life and give them the chance to get back on their feet. Now, I'm going to turn things back to Delaney for our final policy solution.
Great, thank you. So, in addition to these laws and policies we've discussed, local and community-based resources can also play an incredibly significant role in addressing the impact of homelessness and housing instability. So what we've done is identify 3 specific strategies that are key to this community level response, and you'll see those here. So first is adopt a community-wide strategic response. Second is provide immediate rehousing and support services. And the third is promote long-term stability through housing vouchers. So starting with our first one, this is adopting a community-wide strategic response. And this requires that the community provide a centralized response system to community members who are homeless and at immediate risk of homelessness. And this is important in many ways. So it first provides for a coordinated point of entry, specifically a centralized intake process. And this helps to ensure a holistic screening of the community member in need and increases the quality of assessment while also identifying effective assistance for that individual who's seeking support. Second, a community-wide strategic response ensures that the office is able to look at prevention strategies and resources more broadly for the community as well as at the individual level. And then finally, third, this allows the office to collect data to identify homelessness risks and needs, and then to inform its community response and planning. So then moving to our second strategy, this is providing for rehousing and support services. So there are 2 common types of rehousing resources here. The first is rapid rehousing. And this is a short-term resource that's designed to quickly reconnect people experiencing homelessness with permanent housing. And so because of this, it's short-term in nature. It includes some assistance in finding housing, short-term financial assistance for rent or moving costs, those type of things, and then case management services for people as they're housed. And the fundamental goal of rapid rehousing is to reduce the amount of time someone is homeless or to eliminate the period of homelessness altogether. So importantly, rapid rehousing is an effective intervention. People who have access to rapid rehousing have shorter homelessness episodes, are less likely to return to shelter once their financial assistance ends, and most do not become homeless again. And this quick transition then in turn reduces those people's risks of the poor health outcomes associated with homelessness. And even beyond the individual, this also helps our communities by creating greater availability in shelters and other resources while being a more costly option than many other housing resources. So then the second common type of rehousing resource is permanent supportive housing. And this provides permanent housing and support services to people who are chronically homeless. So like rapid rehousing, permanent supportive housing is shown to be a positive and effective intervention. One study showed that permanent supportive housing reduced chronic homelessness by 20%. It is also linked to lower costs expended in public services, in hospitals and healthcare, and in jails and prisons. The Department of Housing and Urban Development, which I'll call HUD from here on out, details the housing first approach to permanent supportive housing, and it includes a number of important components to consider when operating a permanent supportive housing facility. And these components really emphasize ease of access. So we want to screen people into housing, not out. We want quick and easy transitions into housing for people. We want services to be accessible but voluntary. And we want tenants to have the full spectrum of rights and protections that any tenant would have. A New York City initiative really highlights this. It provided permanent supportive housing to chronically homeless individuals upon release from incarceration. And it illustrates the impact of these programs because it showed that people who were given housing were less likely to return to jail or shelter as a result. So HUD provides grants for both rapid rehousing and permanent supportive housing through the Community of Care program. And those are grants that are accessible to nonprofits, state and local governments, and public health agencies. So then finally, our third strategy is more focused on longer term housing stability through the accessibility of housing voucher programs. So vouchers allow a family to provide less in rent because the state supplements the remaining amount. The amount a family contributes depends on their income, but is usually around 30% of that income. There are generally two types of vouchers. You may have heard this before, a tenant-based voucher and a project-based voucher. A tenant-based voucher attaches to the family and follows that family wherever they live, whereas a project-based voucher attaches to the specific dwelling or rental property. So vouchers are hugely impactful at promoting housing stability among community members who are at risk for instability or homelessness. They are linked to reduced rates of hospitalization, food insecurity, intimate partner violence, and child separations. These programs help families meet their basic needs and reduce the negative health risks associated with that homelessness and instability. Now, most vouchers, like a Section 8 voucher you may have heard of, are federally funded through HUD's Housing Choice Voucher Program. Federal Housing Choice Vouchers are administered by local public housing authorities that receive federal funding from HUD to administer the program. The majority of funds do go to tenant-based vouchers, but there is some flexibility for a small percentage of funds to go to project-based vouchers. The Housing Choice Voucher Program also includes the HUD VA Supportive Housing Program, which provides this sort of assistance with support services to veterans who are homeless. HUD vouchers have an undeniably broad impact. About 2.2 million households use these vouchers for privately owned housing. However, the limitation is also really significant because there is a huge backlog on this list, and many families who qualify do not actually receive the assistance because of how significant the backlog is. So considering the need for and benefits of those voucher programs, it can be incredibly beneficial for states and municipalities to provide local subsidies to invest in vouchers for community members, separate from and in addition to the Housing Choice Voucher funding. HUD details the benefits of this in its Moving On program. It identified New Jersey's state rental assistance program as one such resource, where the state provides access to tenant and project-based vouchers to community members, separate from the Housing Choice Voucher funding. And we actually have a similar bill proposed here in Baltimore City this session. So while HUD provides the most substantial funding for housing vouchers, states and municipalities can supplement those efforts in meaningful ways to address the program's lack of accessibility, despite many families being financially eligible. These strategies, the strategic response, rehousing resources, and voucher programs will help to build a centralized response in our community to better respond to and prevent homelessness and instability within our communities. And that brings us to the end of our presentations. Again, these practices have the potential to have a great impact on housing instability within our communities. And now we look forward to answering your questions.
Thank you so much to all of our presenters. I hope that all of you have learned a lot of information today about legal and policy approaches to addressing housing instability. There was a lot of information here today, and so the slides are going to be available on the network website. You should feel free to go and download those so that you have access to the information that was presented today. And as I mentioned earlier, there will be a law and policy pathway document and fact sheets that discuss all of the information that was presented today as well. So I am going to do my best to address all of these questions that were asked during the webinar. I will be continually monitoring the Q&A session. So if you have additional questions occur to you as we're talking here in the next 30 minutes, feel free to put those in the Q&A as well. So the first question was directed to Molly. And the question is, a large number of rental properties in the US are now owned by venture capital firms, mostly purchased in the wake of the housing crash after 2008. In Seattle, it's about 40% of all rental properties. These firms feature remote ownership, deep pockets, and an industrial approach to eviction and collection practices. What can be done to address the movement of venture capital in the housing market? Not an area that we have done an extensive amount of research, but I am curious to hear the reactions of our panelists. And we'll start with you, Molly.
Sure. Yeah, thanks for that question, Michael. It is a great question and obviously a very real issue. And I don't think I have a great answer to it specifically, given what Carrie said. It's not something we've been looking at directly. But I do think one thing that we can do is to discourage these companies from treating their tenants like commodities, and to encourage them to treat their tenants more like people. And I think a number of these measures that we've talked about here today are really designed to do just that, to kind of stop the turning and churning of tenants through the eviction process. And the policies that make the eviction process more costly or more difficult for these big, larger corporate landlords are hopefully going to then encourage them to turn to more actual relationship building with tenants to solve issues, rather than encouraging them to turn directly to eviction as a cause. So not a full answer, but those are my initial thoughts.
Yeah, that makes a lot of sense. And Kyle, I don't know if you wanted to chime in here too. We've had a little bit of exposure to this venture capital issue with some work that we've done in Prince George's County in Maryland. Any gut reactions to this question that you have? I'll put you on the spot.
So it's hard to say. What I sort of see happening based on our limited work is that there's a bit of a disconnect between distant, remote landlords and venture capital firms and the people who are actually living in the houses and facing challenging conditions and any of the other issues that can come up when you have distant management like that. To me, my gut reaction, since you put me on the spot, Carrie, is that the best way to address this problem is to put in place more jurisdictional protections for tenants to assert habitability claims, to protect themselves or withhold rent if the landlord isn't upholding their part of the bargain, and just to in general buttress their tenancy so that tenants who can't necessarily afford an attorney still have an option to protect themselves against landlords who are just viewing them as part of the bottom line. That's my answer on the spot. Does that answer your question?
Yeah, Oh, I'm sorry. Yes, I think that's great. And I think what we've learned is that whatever the answer to that problem is, and it is a major problem, it's not going to be found in rent court, right? It's gonna require a more global policy solution, and definitely something that should be tackled sooner rather than later, because it is a major problem and it's growing. Okay, next question. And this one is for you, Kyle. Allison says, I'm evaluating an early housing stability intervention program in Boston. Can you suggest reports or papers that have been published from other eviction prevention programs?
So absolutely. As I mentioned in the presentation, these programs are fairly new, so the literature is still a little scattered, but there are some good reports out there. First, I would start with a website called Eviction Innovation. Eviction Innovation just aggregates statistics and data and links to websites for programs that have been enacted around the country. If you want something more specific, in 2018, the Philadelphia City Council published a report that studied the housing and eviction crisis and reported on prevention programs around the country. I can provide links to these materials over email afterwards, or even post them in the chat now if you think that'd be advisable, Carrie. There are some other options. There's nonprofits such as the Urban Institute that have studied eviction prevention programs on their own, and I found a great survey of programs on their website. And finally, there was a law review article published recently called Everyone Loves the Landlord, Evictions and the Coming Prevention Revolution in the Mitchell Hamline Law Journal of Policy and Practice. This was published in 2020. Again, I can provide the citation on request, so I'm happy to connect with you over email separately, Allison, or to post these links in the chat.
Great, Kyle, thank you. So this question relates to right to counsel. So Molly, I'll send this one to you. Are there any models for having legal representation for tenants that is not done by lawyers per se? So lawyers are expensive, but there might be a way to have trained legal assistants that are lower cost to help tenants. Sort of similar to the model in Maryland where landlords can be represented by agents.
Yeah, that's a great question. And I don't know the answer to it specifically. I know it's being talked about kind of around the country. And I do think it's interesting that it's an option for landlords, like you were just saying, Carrie, here in Maryland, to use an agent rather than a lawyer. And that same opportunity is not open to tenants. So it is definitely something I think that's worth considering. Happy to follow up more afterwards with a little more specific information on that.
Great. Okay, Delaney, we had a question come in while you were speaking about stable housing. I have to try to find it. Oh my goodness, so many questions are coming in that I've lost the ones that I earmarked. Okay, here we go. So Nicole Sutton asks, I recently heard about something called deeply affordable housing. Would that be considered a form of permanent supportive housing? Have you heard of that?
I actually had not heard that term, but I did quickly Google it when I saw the question. So I think I can't say for sure. Permanent supportive housing is an affordable housing program and resource. So I think it would overlap with deeply affordable housing in that way. I think it would probably come down to the specifics of how the housing is hosted and whether there are support services available to the people who are being housed there. So and as well as how those people are qualified to enter that housing. I think it would come down to those sort of factors.
Great. Okay, so this question from Benjamin Larson is about sealing eviction records. So Kyle, this one's for you. And I should say anybody who wants to chime in on any of these questions, feel free to do so. But Kyle, he says, thank you for the thoughts on sealing eviction records. I agree publicly filing records are problematic. Does the panel know any strategies or recommendations for data collection when records are sealed? I know of many service providers who use public data to inform.
So that's a great question, and it is a trade-off. If information is sealed or if records are expunged and destroyed completely, then obviously they're not available for data collectors and service providers. One of the advantages to sealing over expungement is that sealing does allow records to be provided to certain individuals in limited circumstances. And so it is possible that a jurisdiction could enact a sealing law that allows records to be unsealed for the limited purpose of data collection and epidemiological study. The key, though, is that it needs to be a narrow form of unsealing. Going back to the Wisconsin law I mentioned earlier that requires records to be taken off the internet after 2 years, that law has been found to be practically unenforceable because once information's out there, we all know how the internet works. It's out there. It's in the wild. It's very hard to delete it from every possible website. So any solution here would need to be balanced so that public service providers who have a legitimate research reason to study the data could access it, but it wouldn't find its way onto the web for landlords.
Great, thank you, Kyle. So this is kind of a global question. I'd be curious to get your thoughts on it, any of you. Eric Pankow writes, do you believe that tenants should be able to file a foreclosure in order to prevent an eviction? I wonder if they mean landlords should be able to file foreclosure. I don't know. Any thoughts on that? You know what? I think we should do some follow-up research on that one and get back to you, Eric, to see, to clarify your question. Or you can retype it in the chat or the Q&A. That'd be helpful too. Molly, question about funding sources for right to counsel policy. So Melissa Thate writes, Denver is pursuing a right to counsel policy. What are the most common funding sources to pay for legal counsel? You mentioned that these programs are expensive. Is it more common to have in-house counsel or partner with nonprofit legal assistance providers?
Thanks, Melissa, for that update. I know there are a few updates in the Q&A there about other local efforts, and I think that just goes to show that there's some real movement in this space. So great to hear that Denver is also considering implementing a right to counsel. And the short answer is it varies. So different jurisdictions have approached it differently. Here in Maryland, legislators are looking at funding the implementation in part through an increase in filing fees. Though that has met with some opposition from landlords who say that it's unfair to ask them to fund their opponents, essentially. In Boulder, the eviction defense program is going to be funded through a new excise tax on rental licenses, which again is putting the cost on landlords maybe a little bit less directly. Some other cities have just relied on appropriations from general funds and haven't really specified a funding source. So there's really a mix of approaches, but obviously it is a big question that any local or state government is going to have to tackle. And in terms of implementing or kind of administration of the right, again, there's kind of a range. So a few jurisdictions have looked to legal services to administer the program. Others are providing funding directly to nonprofits who are already doing this work, maybe on a smaller scale. And others seem to be hiring attorneys more kind of in-house to handle eviction cases. Interestingly, a few states, I think Washington, South Carolina, and maybe Nebraska are looking to require the court to appoint an attorney if the court determines that the tenant can't afford one for themselves. So that's kind of another approach. So again, sort of a range there too.
Awesome, thanks, Molly. So this isn't really a question, it was more a reaction, but I wanted to share it with you because it's great. So Michael Weisman writes, whoa, we have prohibited landlords from using criminal conviction data against tenants or to screen tenants. That should be prohibited everywhere. I think we can all just give a giant amen to that. Any reactions before I move on? I have another question.
I think
you covered it.
Yeah, I'll just briefly echo the amen and say that, yeah, there the comparison's pretty stark. I mean, in criminal records, at least there's some justification due to the nature of the conduct involved. But here we're just talking about people who are poor, who couldn't make their payments, who struggled due to a pandemic. That's not the kind of thing that you'd expect would follow someone with many of the same implications as a felony filing against them. So I share your surprise when I learned about this semester, and I think something needs to be done about it.
Yeah, and we do have a question here about asylum and undocumented people, and whether there are any specific resources for undocumented folks. So at the law school, we do have an eviction prevention project where we do work with clients, many of whom are undocumented, and that's always a really difficult line that we have to walk, right? Because unfortunately, that we can't guarantee that the landlord won't retaliate and report them to ICE. Unfortunately, that's not prohibited. So as far as resources, we would be happy to do some additional research and get back to you on that question. Any additional reactions from you guys? I didn't want to just monopolize that. Okay. Yeah, I mean, that's just it's a horrible fact that it's just a population that's largely ignored by these policy implementation, and approaches. So Kyle, this question is directly aimed at you. It says, Kyle, do you think it's possible to make the case for sealing eviction records that do not rely on the argument that, quote, landlords can look at criminal records, unquote? There are problems with allowing landlords to look at criminal records due to the inaccuracy in background checks, the continued availability of non-conviction criminal records, the continued availability of old criminal records, etc.
So to respond head on, yes, I do. I think among all the options I listed, criminal records are also not a very strong determinant of a tenant's ability to pay the rent right now. And as someone just said in the Q&A, felons need housing too. I'm 100% for banning the box. I know that's not our main focus here today, but we have a very similar cycle in returning citizens as we do here. So the way the argument can be made is just by highlighting the other resources that are available to, again, highlight current financial stability. The entire point behind screening applicants for housing is so that landlords can make a safe investment and make sure that a tenant is able to pay. And this can easily be accomplished by requiring them to verify their employment, their source of income, having family members or others attest that they'll provide support, conduct interviews and require attestations under oath. None of these techniques require any look at someone's criminal background or eviction background. So I think the argument is just as stable.
Thanks, Kyle. So this next question is a big one, so I'd like to give you all a chance to kind of react to it. Allison Bauman writes, what are your thoughts about how these policies are framed in the media and in public discourse? So I'm thinking about framing them as housing stability policies versus eviction prevention. Eviction may have a certain connotation for people. Do you know if the public at large would support policies that are framed as promoting housing stability versus preventing eviction? Words are important, right? And so I appreciate these efforts to kind of get buy-in. So what are your thoughts on that? And I'll give that one to you first, Delaney. And we'll do a round robin.
Yeah, I mean, I think it's a great question. And I do think, I think there are people with more community organizing perhaps experience than me, but I do think that we respond better to positively framed issues, certainly. So I can see the idea of promoting housing stability versus preventing eviction maybe just sounds, it's a more positive approach to the, ideally the same issue. I will say, I think something that Molly, Kyle, and I, and all of our team has been really focused on is trying to avoid a us and them mentality as we approach these issues. People who experience instability and who experience homelessness are members of the community just as all of us are. And so I think for our framing, it was really important that we approach it not from a us and them perspective, but as a how do we as a holistic community promote positive goals for our community, and that benefits all of us. And so I absolutely think you're right that in how we frame that, it makes sense. And so I could see how kind of framing it in that way as opposed to eviction prevention does help send that message. That being said, I also hope we move to a place where all of what Molly and Kyle talked about with eviction is not, we see that that term is kind of leaving a black mark on people in a way that it really shouldn't. So
What do you
I can
think,
just
Molly?
add on to that. Oops, sorry, Carrie.
No, go ahead. I was calling on you. It's perfect.
Oh, perfect. Yeah, just to add on to that, I think something else that we have tried to be mindful of in the way we have thought and talked about these different issues is also not always pitting landlords and tenants against one another. And eviction is obviously an adversarial action. So I think, in framing policies as promoting housing stability or even, reducing housing instability, it doesn't automatically, kind of assign two sides to the issue. And I think that probably even the term eviction and eviction prevention may get some landlords hackles up. I think rightfully in some cases, landlords, will say that they have to be able to evict tenants. So, I mean, the goal isn't necessarily entirely to prevent eviction. So I think, again, that framing of stability and instability as opposed to something that's more adversarial is helpful for public buy-in.
Awesome. Kyle, I'll give you an opportunity to chime in on this. I know you have some thoughts.
Yeah, I think Molly and Delaney covered this very eloquently. The only things I will add are that there's a surprising amount of stigma baked into this process, really on both ends. In some of the studies I read, regrettably I can't recall their exact origins. There have been panels of landlords pulled together to have a dialogue about eviction and about the costs associated with the process and what the landlord-tenant relationship looks like. And in that study, they found that the word tenant had a surprising negative connotation for a lot of landlords, and the word landlord had a negative connotation for a lot of tenants. And so unpacking that stigma is so important because parties need to realize that that there's a lot of struggle. There's a lot of people in this process who are just trying to make ends meet. The second thing I'll say is that a lot of the landlord benefits to the programs we've discussed are very subtle. And like a lot of public health measures, it takes a concerted effort to educate people about the downstream benefits to the party that already has all of the resources. For example, in my slide on eviction, the benefits of early intervention, I discussed that the cost of eviction in some cases can be upwards of $10,000. In fact, a report by the Boston Housing Authority found that the average was, I believe, around 12,000. So there are all of these subtle costs that people aren't necessarily aware of, and just making them aware of kind of the risk calculus involved with eviction versus support could help shift the needle on public discourse.
Thanks, Kyle. That's really helpful. We did have a question about mediation, but I'm going to hold that one to ask you, Molly. Shelley Cavalieri writes, very curious about whether the team thinks institutional or corporate landlords should be engaged differently in these processes than mom and pop landlords, and if so, how and when. What do you think about that one? And Delaney and Kyle, feel free to chime in after Molly.
Yeah, I think Kyle spoke a little bit to this, but in a lot of ways that calculus is very different for an institutional or corporate landlord than it is for a smaller mom and pop landlord or somebody who manages just a few properties. In those cases, the threat of eviction maybe carries more risk for the landlord as well, in that, if they actually go through with it, they're going to be shouldering those costs that Kyle just mentioned. And that calculus is just different for larger property owners. I think a lot of the policies that we've talked about, especially things like those that deter the practice of serial eviction filing, really are geared at those larger corporate landlords. Generally smaller landlords are not using that practice as much as those larger landlords are. So things like raising filing fees, while they will impact all landlords, they're really going to impact the landlords who are filing repeatedly and using that process when they maybe don't have to. Smaller landlords are naturally going to tend to work with their tenants or have a relationship with their tenants in a way that those larger or out of state, like we were talking about, landlords just aren't. So I think some of these policies they impact those different kinds of landlords differently and are intentionally that way.
Any thoughts, Delaney or Kyle, on the corporate versus mom and pop and how to deal with them policy-wise? Differently, the same?
I think Molly captured it very well.
I agree. Okay.
Actually, can I just add one other quick thing?
Sure.
Just because something that we noticed in listening to a number of landlord-tenant bills in front of the Maryland General Assembly this session is just how much opponents rely on the small mom and pop landlord as a reason not to implement these policies. And there's so much emphasis on how much it's going to cost smaller landlords. And just the reality of that doesn't quite match up, because it's, again, you're talking about people who, smaller landlords who really don't want to have to evict their tenants, whereas these larger corporate landlords, want to be able to file and collect these additional fees and see it as a way to control their property. So that the relationship is just so different that it feels like, a really inept defense to the policy.
I actually do have one quick addition to that. And it goes back to the first question we were asked in this Q&A, which is that an increasing percentage of rental properties around the US are owned by large capital firms and industrial landlords. And I think highlighting those percentages and those trends can really go a long way towards helping people understand which populations are going to be affected.
Thanks, Kyle. So I did want to note that I see, Molly Wells, I see your comment here about mediation and the feedback that you have regarding the service gap for Kalamazoo, I think it was. We will take that into consideration for sure. Really appreciate your feedback. It'll help us shape the fact sheet on eviction diversion programs and mediation as part of that. So final question that I think is here. There's another comment from Michael Wiseman. Between venture capital, hedge funds, and Chinese owners, the vast majority of rentals in Seattle are corporate owned. I think that that's a growing trend around the country, and definitely something that we'll focus on as we move ahead with the network products that we're developing. So Kyle, about mediation, are you familiar with examples of recent efforts to set up nonprofit mediation law firms? And I know that you've done a lot of research on mediation for the eviction diversion program bill here in Maryland, which was, required a lot of nationwide research on your part. But has that come up at all in your research?
So that actually hasn't. I've studied more the eviction prevention aspect of mediation specifically than ADR and mediation services in general, but that does sound like an interesting avenue for further research. What I can say is that most of these programs have involved, well, some of the programs have involved integrated services through in-court mediators, such as ADR offices. Others have involved community mediation centers and outreach and partnerships. And so that seems like an interesting avenue to set up similar partnerships. So thank you for that question. And I think it's something we can look more into.
Great. And I think we have exactly 60 seconds for the last question, which I'm sorry I missed, Sonia. Did you identify challenges or provisions to address housing needs of people who live in areas such as DC, where increasing costs and limited inventory may push people to seek housing in neighboring jurisdictions where they may not be able to use their existing housing benefits? Delaney, this sounds like a question for you. Do you have any thoughts on that? And Sonia, we can follow up with you as well.
Yeah, I do. Absolutely. So I didn't see anything specific to that. And I think the reasoning is because that actually bumps up against the fact that these programs are managed at the state level, even if they are funded by federal programs. So I do think, you know, to your point, it's a good one. I do think there are significant issues, especially around, you know, really populated and high rent cost areas. What I would say is, in terms of if you have any practical interest in this, my experience is that local community programs and nonprofits that work with people experiencing homelessness are really knowledgeable at identifying how to work with people such that they can qualify for programs in that specific jurisdiction. So I think they have a lot of experience at that. When I was a social worker, we worked on the border of New Hampshire and Vermont, and our programs were very knowledgeable at how to, you know, work with someone who may be transitioning between those states. So I would definitely recommend, if you have an interest on the ground level in your community, reaching out to your local programs, because they probably are very experienced in navigating that issue, unfortunately. But it's a great question.
Awesome. Thank you, Delaney. So we are out of time. Time flies when you're having fun. I want to thank you all on behalf of the network for being here this afternoon. Special thanks, really, you guys, to Delaney and to Kyle and to Molly for all of their work in preparation for this webinar, and all of the work that will go into the products that you will see on the network's website here in the coming weeks. If we did not get to your question, we will do our best to follow up with you. And always remember that you can reach out to us through the technical assistance feature on the network's website. Again, thank you for being here and have a great rest of your day.